Welcome to Council Culture, the Business of Law podcast brought to you by Byfield.
Hello and welcome to another episode of Council Culture, Byfield's Business of Law podcast. Today we have a very special guest with us. We have Professor Stephen Mayson, a strategist, independent legal thought leader, and a powerful advocate for fairness. Stephen is renowned for helping organisations navigate structural and industry upheaval with clarity and conviction. Known for his sharp sense of justice and unique perspective, he's a trusted guide to boards, law firms, regulators, and policymakers alike. Whether serving as a non-executive director, strategic advisor, or policy influencer, Stephen brings a rare combination of independence, insight, and integrity to the table. Hello, Stephen. How are you?
I'm very well, thank you, and thanks for the invitation to join you today. I'm delighted to be here.
No problem at all. We're also joined by Gus Sellitto. How are you, Gus?
I'm good, thanks, Olivia. How do I follow that introduction?
Yes.
Stephen, we are delighted to have Stephen on the show, and I was just saying it kind of completes the trilogy because we had the also very esteemed Guy Beringer on our podcast in two episodes talking about the Institute of Business Ethics task force on the law and the law as a profession, and this follows on very neatly from that. So lovely to have you here.
So I guess we could just sort of dive in with an introduction to yourself, Stephen, and your work.
I'm not sure I can do any better than the introduction you've already given me, Olivia. Thank you very much for that. Lawyer by background, spent time in city law firms as a tax lawyer, moved on to strategy and consulting work with law firms around the world, corporate and government legal departments, then segued into non-exec director appointments. I've had a long-standing interest in regulation going right back to David Clementi 20 years ago now, and that's been the focus of a lot of my policy work over the last 20 years. Combined for 33 years now as a professor in one or more usually prestigious law schools.
Fantastic. I mean, is there any sort of tenure that you've really enjoyed the most, or?
I always find that difficult because when you've done so much in different ways, they all have their own highlights and often magic moments. So I'm not sure I'd single anything out in particular. I did enjoy carrying out the independent review of legal services regulation from 2018, as that gave me a real opportunity to think quite deeply about the nature of the profession, its regulation, how the regulators and the professional bodies should be working together, and it allowed me to talk to some very influential people about the issues that raised, and hopefully to come up with a sense of where we might go in the future. I know government is always short of time and space to look at things like legal services regulation, but I hope when they do get around to it, as they surely must at some point in time, that I've done a lot of the groundwork that will help clarify the thinking and the options at that time.
That must be a fantastic feeling as well, to really have an input. And it's great to know that, you've had such a colourful career and you can't really pick a best moment, which is a testament.
Just going back all the way to Sir David Clementi's report, and you talk a lot about consumers and consumer harm and the public interest. And I remember the Legal Services Act, that's when really the consumer started to be talked about a lot more. Fast forward to today, and we talked about the IBE, the Institute of Business Ethics report, which looked at a very particular area of decision-making, putting ethics at the heart of decision-making for the profession in areas of kleptocracy, grand corruption. I think we had that interesting conversation. What is grand corruption? and just plain old corruption. And state capture. But your thesis, your ideas around the public interest and the legal profession having to have the public interest in its mind when taking on clients was very much at the centre of some of the thinking in the IBE report. You then, in 2024, October, I think, you published your report for UCL. Mm-hmm. So talk us through this notion of the public interest and putting the consumer and the public before very much as I understand it, sort of taking on a client, you really need to be thinking more broadly about, is this in the public interest?
Yeah, the public interest is even I'll admit, it's a bit of a slippery concept because it has so many different dimensions to it. And I think anybody is hard pressed to say, here is a definition of what the public interest is about. But it is in the 2007 Act as a regulatory objective. And so we ought to have some sense of what that means. Now, I happen to think that although it's there as one of the nine objectives, it's not given the prominence that I think it should have. Because if regulation ultimately does not serve the public interest, then what is it for? You talk about consumers, they are part of the public, but the consumer interest is a rather specific idea within the much broader set of what do the public, what do citizens expect from their legal system and those who provide advice and services. So I really wanted to step back and say, well, can we have a better crack at what this thing called the public interest might be? And I tried to do it from first principles. I looked at what a lot of other people had said about the nature of the public interest, not just in law, but generally, and then tried to focus it in on what that might mean in the context of legal services. And what I came up with, and I hope it's rational rather than idiosyncratic, but to me, the public interest has two dimensions. The first is building and maintaining the fabric of society. Because if we have no institution of society, then again, what's democracy about? What's public about? What is the state about? And in law, that's very much about the public interest in a wide sense, but the rule of law, the constitutional principle of the rule of law, as the Act calls it, it's about the administration of justice and having a structure for framing your legal rights and resolving disputes about legal rights within an accepted, strong, robust framework. So that's the fabric bit. The second part of the public interest is what I call the legitimate participation of citizens in that society. It's all very well having your fabric of society, but if as citizens you can't play any part in it or can't play a full part in it, then again, what does it mean to be a member of the public, to be a member of society? So I'm very clear, it's legitimate participation. So when you think about things like kleptocracy, I'm not about criminals taking advantage of legal rights. It's about those who have a legitimate right to be here and want to play, as it were, legitimately within that framework to enact and pursue whatever rights they've got. It's about access to justice. And if you've got rights, but you can't get any advice or representation about those rights, then the rights have no value. They have no meaning. They have no purpose in the end. So it's those two things. It's the fabric of society and the legitimate participation of citizens in that society. And that flows through into lots of aspects of what we mean by the public interest and the regulation of lawyers and legal services.
You talk about, and connected to your work on the public interest, you also talk about the law as a profession.
Yeah.
Why is the public interest so important as it applies to the legal profession and lawyers?
That was a major part of the report I did in 2024 on the meaning of the public interest, because the view that I'm advancing there, or in fact reinforcing there, is that the very idea of a profession is a privilege that is granted to a certain occupational group. And the privilege is granted, in effect, by the state. In other words, on behalf of the public. So if you're a member of a profession that has been given that privilege, effectively on behalf of the public, my view is that you then owe a reciprocal duty to the public to act with integrity and in the interests of the public. So the two things for me, the public interest and law as a public profession in that sense, go together. You can't be a member of a public profession if you don't respect the rights of the public and the public interest, not only in in the abstract, as it were, but in the way in which you perform your role as a member of that profession. And that's why I think the two are very strongly interconnected. And I have to say, I think that's a connection that's been lost in recent years, and that's when we get on to a lot of the talk about professional ethics.
Yeah, I mean, I completely agree. I think as a profession, there's that element of trust there, and if that's broken, it's very hard, A, to mend, and B, to get back. So I completely agree. And I think your report mentions the high profile cases and especially sort of the post office scandal. What can we learn from this in relation to the public interest test for justifying which clients law firms act for?
I think to a large degree, the post office cases aren't really about the choices you make about who to represent. They're more about how to represent, having taken that work on. And we can come back to that. To go back to the IBE report and the kleptocracy, you've got a group of people there where generally the public would say, no, these people they're not playing a legitimate part in society. And so why are lawyers representing them? Why are lawyers enabling or facilitating or helping them to launder dirty money through the London Financial Centre or through the English property and legal system? And so the two, I think, they're connected, but they're different. The question of choice of client is a problematic one. If you're a barrister, you have the cab rank rule. And if somebody comes to you and what they want you to do is within your area of competence, you are bound professionally to take that client on. So you don't have a choice. And that's for two reasons. One is to make sure that even people who are accused of doing some pretty heinous things can nevertheless get legal advice and representation. Or even if they're thinking of doing heinous things, at least there's a lawyer with an obligation to say, no, you really shouldn't do that. But there is access to that advice and representation as a matter of professional obligation. So there's that element of not having a choice. Now, solicitors generally don't face the cab rank rule, even the solicitor advocates. And so there's a question about, are you making a choice about taking on these undesirable people? And I think the honest answer is yes, they are making a choice about taking on any client. They sometimes dress it up as saying everybody's got a right to representation. Well, they don't in non-criminal matters. So clearly there is a choice to be made, and I would say that's a moral judgment that a lawyer is entitled to make in saying, yes, I will take on you as a client or that as a matter for legal advice. And there is a moral choice to be made about whether or not you do that. And I'm happy for lawyers who are not bound to take it on to make that choice. I do think, if pressed, they should justify on what basis they've made that decision. That's a separate issue we might come on to. But it is a moral choice. And that's the point at which personal morals and legal advice and representation do coexist. But once you've made that choice, then as a professional, you are bound to do your best for that client within the bounds of the law, subject to the public interest. So there's a threshold. You get a choice up to a certain point. Once you've exercised that choice one way or the other, if you exercise it in favour of acting, you are then bound to represent that client, that cause, to the best of your ability, subject to any legal constraints. So that's a slightly different issue about the post office cases, where clearly the client was taken on. Some cases, the lawyers were employed, so they were almost bound to advise their own internal client. There, the question, I think, is how you choose to represent. And that's where I think we've got a clash of two principles or interests. So, on my view, you've got the public interest, overriding concern for a member of a public profession, but you've also got a duty as a member of the profession to act in the best interests of that client. In fact, that's also contained within the 2007 Act as a professional principle. The problem is that, in my view, far too many lawyers have taken that principle to act in the best interest of their clients as an absolute duty. And they then do it to the exclusion of everything else. In fact, one of the external lawyers to the Post Office said in the Post Office inquiry, it is my absolute duty to represent the client, to represent the best interests of the client. But I don't believe it is an absolute duty, because you've also got duties to the public interest. So at best, it can only be a relative duty. You've got two duties to balance, but the regulators have been quite clear. Where there's a conflict between those two, the public interest takes precedence. So if it does, representing the best interest of the client cannot be an absolute duty. It's clearly got to be subordinate. But that, I think, is where a lot of the problems have been driven. So you find lawyers, litigators, not exclusively, but more often than not, taking some very aggressive, assertive, and in many cases unethical approaches to representing the best interests of their clients, because they're doing that to the exclusion of everything else. And that, I think, is where the problem has come.
And how does this come into question when, a lawyer is representing their client and they are saying it's my absolute duty to do that, and at the time it might not really be picked up? When does it come to light, and when is it highlighted, actually, that wasn't in the public interest?
And therein, I think, lies both the opportunity and the problem. So a lawyer acting for a client can take that view. I'm acting absolutely in the best interest of my clients. I'm going to do all these things. I'm going to say things to the opposition. I'm going to say things to other parties. I'm going to say things to third parties that pursue my client's interests to the exclusion of all else. And for as long as nobody stops them, that's what they're doing. Mm-hmm. And to an extent, they're getting away with it. So it only comes to light when there's probably a hearing, and a judge might say, hang on a minute, you're going a bit far there, aren't you? Or, can you justify that statement? Do you have the evidence for that statement? Why were you so aggressive? Why did you issue multiple sets of proceedings? It just seems designed to grind the other people down or outspend them. And that's denying them their rights, not just enforcing your client's rights. You're having an external effect beyond your own clients. Or there's a public inquiry, as there is in the Post Office, because something has gone so catastrophically wrong, and in that case on so many levels and so widely and against so many people, that the government of the day is then drawn to say, well, we've got to have a judge look at all of this in detail, and then it comes to light. Okay. And of course, in a public inquiry, the judge has got the power to call for the evidence, to call for the emails, to look at the trail of who said what to whom, how aggressive it was, how robust it was, how misleading it was, whatever. And that's when it comes to light.
It's very damaging, though, isn't it, Stephen, to get all the way to a public inquiry, damaging to the reputation of the profession, to then really see what's in the public interest, because it's resulting in a public inquiry. Where there are grey areas, you talk about grey areas in your report as well, around things like NDAs. NDAs have been very much demonised post Harvey Weinstein, and rightly so in any criminal context. But NDAs are still used for valid business purposes. So there's a grey area.
Yeah, and I suppose it's not the NDAs that are the grey area, it's the use of the NDAs by lawyers for certain purposes that are the grey area. So you can have a very good commercial reason for entering into an NDA. If you want to sell a business to me, I want to find out about that business. I'm going to need some of your confidential, maybe even secretive background data in order to make an informed decision about whether or not to acquire that business. So in order to exchange that data, it's perfectly reasonable that we'd enter into a non-disclosure agreement. You will tell me these things, but I must not use it for any other purpose. And that's perfectly good use of an NDA. There may be pragmatic reasons for entering into an NDA. So an employer might think an employee has done something wrong, can't prove it, employee fights back, threatens employment tribunal. As a pragmatic matter, this could take hours, it could cost tens of thousands in legal fees to fight. Let's just take a pragmatic view, we'll settle on a number, on a certain basis. We'll put that into an agreement and we'll agree not to disclose it publicly. You're in a bit of a shady area, but again, there are pragmatic, commercial and personal reasons why you might want to do that. Where it goes beyond grey into black, and I think inappropriate use, is someone who perhaps is accused of doing something criminal, employee rape or inappropriate sexual behaviour, for instance, and you effectively force the victim to enter into an NDA and not to say anything to anybody. Whether that's backed up with a financial payment or not doesn't really matter. It's suppressing information that you could say is valid information to be in the public domain. Again, some people might say, well, how can you represent someone in those circumstances where they're clearly trying to keep something quiet? Well, the first time you might not know for sure whether it's crossed the line. There's an allegation. There might not be a lot of proof. Nobody probably wants to test the proof. For a criminal prosecution, you probably are not going to meet the threshold. But if the same client comes to you 3, 4, 5 times and saying, can you enter into an NDA on similar grounds for these other people, something should be triggering in the lawyer's mind that says, hang on a minute, is this a systematic suppression of evidence that is either evidence of criminal behaviour or is something of public interest? And that's where, again, you're using a legitimate instrument, the NDA, but for inappropriate purposes. So it's about looking for those patterns. It's looking for not the fact of the agreement, but the motivation behind it and the evidence that might be trying to cover up.
Really interesting, Stephen. And we'll talk a little bit about regulation and the role of regulation in helping to determine and enforce public interests. But how about the role of Parliament? And I'm thinking here of another area that you mentioned in your report, which is strategic lawsuits to prevent the publication. So essentially sort of gagging a free press. And I remember a few law firms being named and shamed in Parliament in the public interest, and I think parliamentary privilege was used to be able to name those firms. What are your views on the role of the media and Parliament in helping to shape and determine what the public interest is?
There's a large part of me that thinks, to some extent, it is Parliament's job to define in any given circumstances what the public interest is. That's what we elect our representatives to decide on our behalf. And if they think that law is required to enact that law. Those so-called SLAPs, strategic law, so it's again public participation, again, possibly a grey area, because there can be legitimate reasons why somebody might not want information in the public domain. It might be commercially sensitive, not just potentially criminal. So there are all sorts of reasons why you might want to take litigation, the steps towards litigation to forestall some of those disclosures. I don't think it's Parliament's job to decide whether that was a good move or not. That's a decision that a lawyer should make on behalf of their client, subject to all the other things we've just talked about in relation to non-disclosure agreements and the public interest. And it is for a judge to decide whether or not the claim is made out. So Parliament, I think, needs to be careful where it sits in these things. And although I'm pleased to a degree that Parliament takes notice that these sorts of steps are being taken illegitimately to suppress proper public disclosure, they also need to be careful that they don't subvert the judicial process and the rule of law in making claims in Parliament that bypass the normal processes of judicial determination. So again, there are no easy solutions to these things. They are quite complex social, political, legal issues where all sides need to tread carefully. And I think on some occasions, none of the respective parties perhaps have been treading carefully enough in this, and then suddenly you get front page headlines of all sorts of things that politicians are very good at knee-jerk reactions. And sometimes these bad cases do make bad law because we've overreacted or reacted in the improper way. So, yeah, I'm happy to see these things aired, but let's keep a calm head and think about why we need to legislate in certain directions, or government action is or is not required.
Yeah, and I mean, in terms of the current reputation of the legal profession, which you have written on at length, based on your work, what do you think can be done to improve it, as well as what you're...
Yes, well, there's an assumption in the question that it needs improving. Yes. I think my overall view on the standing of the profession has probably not changed much in 40 years, and that is it's mixed. You look at, again, driven by the media, driven by politicians very often, things are said about the standing, the reputation, the behaviour, the conduct of lawyers in the legal profession that are not favourable. Sometimes justified, sometimes not. So there is a narrative out there for the public to pick up on, which is, lawyers are bad, they're unethical, they're representing these horrible people. Is that really what we want as a public from our legal profession? And yet there are large parts of the profession who go about their daily work doing really good things for impoverished, vulnerable people who are deprived of their rights, sometimes by the state, doing their very best to put that right. So it's not a universal picture, it's a mixed one. And actually, if you speak to most people who've ever engaged a lawyer about their lawyer, as opposed to the legal profession, they're almost universally positive, because they feel that lawyer has been rooting for them, has been on their side, has done their best, and very often has got them the result they want. So that's a very, very mixed picture that we're dealing with. Again, it's a difference between what happens at the professional level, what happens at the personal level. And if you go back to the way in which some of the law firms have behaved, say, in relation to representing kleptocrats, they've not really been bothered about the reputation of the profession. They're more concerned about their firm's reputation or their individual reputation, which, again, you could argue in the case of a public profession, the public interest is the wrong focus. So I think we do need to, we'll come back to that. We do need to focus on how the profession and its members project themselves. Now, when I say we, who do I mean? Well, you could say it's the regulator's job. Legal Services Board very recently has been taking an active interest in professional ethics. Just had a consultation on that's closed. So we can't say that they're ignoring the problem. Nor should we. What can they do as a regulator? I think that's more difficult, because I think what we need is two things. We need collective effort from members of the profession and their professional bodies. And since the 2007 Act, we've got that difference now between the regulator and the professional bodies. I would love to see the professional bodies step up and truly represent the interests of their members as members of a public profession, to say, here's what we should be doing, here's how we should be portraying ourselves, here are our aspirations. And actually, I think those ethical aspirations should be higher than whatever the regulators might require. If you really want to be a high-standing member of society as a professional, then you've got to do more than the bare minimum that regulation would ever require. So I'd love to see the professions doing that, but it does require professional activity, both individual and collective. But the second thing it needs is enforcement. And that is a role for regulators. And again, I think the regulators have been more than a bit slow on picking up on some of these aspects of unprofessional or unethical behaviour, or frankly, just a breach of the regulatory requirements. And I don't think we've seen enough willingness of the regulators to deal with that.
That's a really interesting point. So we've got the professional code of conduct for lawyers, and the SRA has, I think, shown its teeth a little bit more in the last few years, or certainly wanted to. Resource is always an issue, but those can be very public hearings. Lawyers can be struck off for calling the profession into disrepute. Is that not enough to sort of affirm the role as a lawyer, as a professional, as part of a special profession, and is that also not enough to reinforce the public interest, and not acting in the public interest can have serious consequences?
It would be enough if it was catching all instances of that egregious behaviour. Now, I'm not just talking about minor infractions of the professional one. Everybody will make a mistake from time to time. It's not hang them and shame them and all the rest of it for those sorts of things. But I do think the regulators have been, and I'm talking in the abstract there about all the regulators. They're probably not all as guilty of this as each other, but I'll put them all in the same camp. I don't think they've been as assiduous as they might have been in investigating and dealing with those aspects of unethical professional behaviour that will have been brought to their attention. I agree there's a resource question, but that's also a priority question. And if you believe in the public interest and the public profession and public trust and confidence in that profession, then where you see any suggestion that a member of the profession has behaved in such a bad way, you really need to investigate it and you need to follow it through. And you need to find the resources to do that. It always amuses me that lawyers complain about the cost of the legal ombudsman. The ombudsman only deals with complaints that have not been resolved by the firm itself against behaviour that the firm itself has perpetrated. So if you don't want the cost of these things, which do then get lumped into what the profession pays for its discipline ultimately, then just go back. Can you deal differently with how you react to complaints, how you deal with them, how you dispose of them, and stop them getting to an ombudsman service? That will be expensive because at that point so much has already been lost. But we could reduce the cost of regulation in dealing with complaints, and that would allow the regulatory framework in general to spend more of its time and effort and resource on addressing those things where something has really gone wrong, not just at the client level, but at the professional level.
And in terms of sort of the regulation that you think should be implemented, on the back of sort of the recommendations that you make in your report, what do they look like? Because, you said a lawyer should go above the bare minimum of those regulations set by the SRA or what have you. So what does that look like, the regulation?
That's not always easy to unpick. The thrust of the recommendations I made back in 2020 were, first of all, that the public interest should be the paramount regulatory objective for all the reasons we've talked about. Second issue was that I think we should be clear about the distinction between the regulator and the professional body, and that regulation and the regulator should be focused on the minimum that's required for somebody to stay in practice. The profession should be concerned with the aspiration, the higher level stuff that for me is part of being the public profession. At the moment, we've got a regulatory framework because it came out of the profession that is geared towards regulating to the highest possible level. That's expensive. We can see it's brutally expensive. And the regulators don't have all the resource they need to regulate to that level. Well, Parliament isn't actually saying you need to regulate everything to that level. It sets what the reserved activities are that absolutely require regulation and authorisation. If the regulators were focused on that rather than regulating everything a member of the profession did, we would have a very different regulatory framework. And at that point, I say we wouldn't need, however many it is, I always lose track, 9 frontline regulators and an oversight regulator. We could have a sector regulator that just focused on that minimum. And that, for me, would change the tone of regulation. I think it would change professional acceptance of regulation, because they were moaning about their regulators, but I'm not surprised that the regulators are trying to do too much, and therefore they're charging too much. And as I said, the vast majority of lawyers want to do a good job for their clients. They do behave ethically. They don't need somebody breathing down their neck all the time, but they do need sanctions if they get the bare minimum wrong, and they need a professional body to say, hang on a minute, you're really not behaving as a professional should. We're going to terminate your membership of the profession. So I was really trying to unpick all of those things and look at different ways of getting to what I think we all want to see, but at the moment we've got a rather blunt, complex, multifaceted framework for trying to do it.
So in a way, it is a kind of self-regulation that you would like to see, almost, with the public interest underpinning it.
It would be self-regulation of those higher standards of being a public professional. Yeah, it would not be self-regulation of the minimum that Parliament and the public, I think, would rightly require of lawyers who are really, and it's mainly on advocacy and litigation. The things that deal with disputes and the resolution of disputes and the relationship with the courts, where you really need that focus. And actually, those standards could still be very high, but you're just regulating those standards to a high level, not trying to do everything and failing.
And drawing on Olivia's question, and you talked about this in an article in Legal Futures, where how do you align a law firm's values and sort of stated interests with the public interest? And you mentioned something really interesting in that the lawyers of tomorrow coming into the profession, they care very deeply about things like the environment, who they act for, and if that's misaligned with the firm's way of doing business, it can actually lead to problems, including mental health issues. So how could, it's quite a sort of lofty concept in my mind, but how do you align the public interest more with a law firm's interest?
Well, I mean, first of all, you've got to look at, in any given firm's practice, how the work they do and the clients they act for align or don't with the public perception of what is good, bad, or indifferent. And again, I would come back to this point. Everybody deserves legal advice and representation, however mean or bad or corrupt they might intend to be. Somebody needs to say to them, no, you should not be doing that. And lawyers should be saying that, not bending over backwards to stretch the meaning of the law or legal instruments to get the client as close as possible. So, no, we are not going to advise you to do that because it's against the law and or the public interest. And I don't see a problem with a member of a public profession doing that. So law firms have got strategic decisions to make about what sort of work they want to do, what sort of clients they want to act for. And if they want to act for oil companies, I don't think anybody should say to them, well, you shouldn't be allowed to do that. There may be reputational consequences of them doing it, but they could make that as part of their strategic decision-making framework in full knowledge that by going down a certain route, they will offend some groups, some people, maybe some of their clients. But, all businesses have to make those decisions. At that point, the youngsters who really don't like law firms that act for oil companies would know that here is a firm that does. I really shouldn't be applying for a job there, rather than applying for one and then saying, hey, I don't like this, can you stop doing it? That's not going to work. That's not real world. So I think unless these things are clear and articulated and laid out and explained, clients and youngsters, employees, future employees, they have no basis for understanding which firm they go to and for what reason. And that's why the other bit of the IBE report, although that was, as you say, focused on kleptocracy, but it had broader application. I think if a member of a public profession is going to say, I am acting in the public interest, they should be prepared to say, and this is why I think I'm acting in the public interest. So they need to articulate what they're doing and why they think that's in the public interest. They have to let the public know. And they then have to be accountable. It might be commercially accountable, not accountable to a regulator, because in some of those strategic decisions, there's no regulatory issue. I'm providing legal services to a particular type of client, that nothing is illegal, then they're not a prohibited client. There's just nothing wrong with doing that work for that client. But I might reputationally have to account for that and accept the consequences. And part of the reputation will be with future recruits and young lawyers. And that's something you've got to be comfortable with. But unless you've articulated it and explained it to yourself as much as to anybody else, how can you be comfortable with accountability? Because it's all just confused.
Yeah. I mean, I completely agree with what you're saying there, especially in terms of the accountability and yourself, because I think it must be quite easy to kind of get mixed up in something like this and think that you're maybe doing the right thing and your absolute duty to represent your client, etc. And it does take someone to maybe come in and say, this is actually not acceptable. But as you say, you don't want it to get to the level of it being a hearing and it being very public, and that's where sort of this public interest, having that as the baseline for everything that you do, is so integral to keeping to your morals, I suppose.
I think it's the guiding star, really, around which everything else, if you can think about it in the more rounded way that I'm encouraging, then I think you've got a basis for balancing all of these different interests without transgressing your professional duties, without necessarily making yourself feel uncomfortable in what you're doing and who you're doing it for, and still being consistent with regulatory duties. You may get some reputational kickback, but then any other business is going to get that from time to time, because public opinion can be a bit fickle. And public opinion, public interest, in my mind, are not the same thing. But public interest can shift, and you may get some adverse publicity. Well, if you've made the decision that you're comfortable with for reasons that you can articulate and justify, you have to live with that.
Exactly.
And from what you're saying, the conclusion there as well is law firms have to be more open sometimes in stating why they are acting in certain circumstances.
Yes. And to be fair, a lot of law firms, particularly the bigger ones, do have client intake procedures and processes that they follow when they're approached by all clients, not just those that might be somewhat dubious. I think all we're saying in the IBE report is explain the process to us. You don't have to explain what you took into account, because that might well be client sensitive, it might well be confidential. We're not expecting you to breach client confidentiality in any of this, but at least explain the process you went through, and possibly even the strategy that you are implementing as you make these various decisions. How do they align? And I can see nothing wrong with that. There's certainly no breach of any professional obligation involved in doing that. But the default lawyer reaction often is, oh, well, that's privileged, or it's confidential, or we just don't talk about it. And that's not helping them.
No, I think that there's definitely, as I say, something to be said for this to be the basis, and taking that further even to education level, and making that the sort of universal test. It would be fantastic if that was the case to every lawyer that's coming up in the ranks, to have that, which hopefully, I mean, is a goal, I suppose.
Totally, yeah.
Yeah, absolutely.
Yeah.
What would you like to say? Such an interesting discussion, and in sort of summing up, looking ahead, your latest research and the public interest in decision making, ethical decision making within the profession. What would you like to see as 2 or 3 key areas where you'd say, yeah, that would be progress?
I think an acceptance by the professional bodies and by however you want to describe them, leading law firms, that these are serious issues that deserve a public airing and warrant the sort of transparency that I advocated in my report and the IBE task force did in its report. And that's where you get the basis for a mature conversation about what law firms are doing, who they're doing it for, why they're doing it, and why it's important that they do it for them, for the client, but most importantly, for the public, and how all of that maintains the integrity of the justice system and the trust and the confidence that the public should rightly have in those who provide legal advice.
Well, Stephen, I mean, it's been a fantastic and enlightening conversation, and I think that you've articulated it in a way that's, for me, and I don't know about you, Gus, but very easy to understand as well, which is great. And I look forward to seeing, your work and how this progresses, because it's such an integral issue to the legal profession, and one that we need to bear in mind, because, as you say, it can easily get lost and can end up in quite serious situation. So thank you for your time.
No, thank you.
Thank you so much, Stephen.
Pleasure.
You've been listening to Counsel Culture, the Business of Law podcast brought to you by Byfield. Thanks for listening. Don't forget to subscribe and join us again next week. We'll be discussing some more of the biggest stories in the legal sector.